Hello, this is Matt on the Moon Family Sedan channel. Here's a headline from you today. XRP lawsuit. Crypto lawyer says biggest danger to Ripple might lead to this outcome. And of course, they're speaking about none other than attorney John Deaton, and basically what he thinks perhaps could be, the SEC's perhaps even best argument against it. I don't want to put words in attorney John Deaton's mouth, so I'm going to share full context exactly what he said. That's something that he has cited before. But he cited something I've never seen him cite before. Maybe I just missed it, and if so, fair enough. But he says that it's actual possibility, in his opinion, that when this is all completed, that the lawsuit's over, the judge has come to the conclusion that she comes to, that it may be the case. Like, so even if Ripple loses, they may end up paying nothing more than a fine. There may be no injunction or any sort of additional penalty of any sort, literally just some sort of fine. Now, that would be truly minimal, and even if Ripple loses, that would be fantastic. Not that Ripple lost, but it would be fantastic for XRP holders if there's nothing else coming out of this to the negative. And he does state also that it's a pretty big if. So it's not that he's necessarily completely convinced that this is the outcome, but I thought I'd just mention that at the outset of the video so you kind of get the gist of what I want to cover here, a big part of it anyway. But I'll give you, again, full context, his exact words verbatim, because I don't like putting words in people's mouths. I always have this danger. I don't know about you guys, but it's like honestly, when you're sharing somebody's perspective, just in life in general, doesn't even have to be crypto related, I always worry, like the way that I describe what I believe somebody else is communicating, I always worry if I'm sloppily describing it or I'm not precise enough, even if I think I am, and then I'm unintentionally putting words in someone's mouth. I always worry about that stuff. Before going further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so where did this all kick off? Well, it dates back to 2 days ago, where Paul Gruel, who is the chief legal officer at Coinbase, he shared a tweet which reads as follows. And so he's obviously talking about the Howey case here, but he says, if I grow oranges myself and harvest them myself, the oranges are not securities. If I grow oranges myself and harvest them using a contractor that charges me, the oranges are still not securities. And that was retweeted by XRP community member Stefan Huber, and he shared this screen grab. And I was wondering where this screen grab came from, because he normally shares a source, but he didn't in this instance. It turns out it came from Wikipedia, and whatever, that's fine, as long as it's accurately, stating, from the source, the proper information. Okay, fine. But I was like, where did this thing come from? And what it's talking about is, the Supreme Court decision effectively in the SEC v. W.J. Howey Co. case back in 1946. And the part that he highlighted in the screen grab reads as follows. The test is whether the scheme involves an investment of money in a common enterprise with profits to come solely from the efforts of others. If that test be satisfied, it is immaterial whether the enterprise is speculative or non-speculative, or whether there is a sale of property with or without intrinsic value. Just pause. I just wanted to note, all the nonsense the SEC has been talking about the speculative nature of XRP and this or that has no grounding in law whatsoever. It's to play on emotions and see what they can get away with. They just throw all this BS nonsense crap at the judge and see if they effectively can trick her. It's like they're testing her intelligence, basically. That's how I look at it. And then anyway, the rest of the screen grab reads as follows. Murphy determined that the contracts in issue met all 4 prongs of this test, and so W.J. Howey could be held liable for violating Section 5 of the Securities Act of 1933. Furthermore, Murphy held that the fact that some of the investors chose to use services other than those of Howey in the hills to tend their groves was irrelevant because Section 5 forbids the offer of unregistered securities as well as the sale. So there you go. So even if they're saying, even if there were another company that were servicing hills for other people, back in specifically as it pertains to this case, it wouldn't matter. Howey still, even if they weren't getting business from other individuals, even making the offer is illegal under Section 5. That's the argument. That's the key takeaway. If you make the offer, forget the sale. Sale too, fine. But even just making the offer, that's an infraction. So what did attorney John Deaton have to say? Well, he responded, and this is what he's saying is Ripple's Achilles heel, effectively, if anything. He said verbatim, and again, this is from attorney John Deaton. I've said this is the biggest danger to Ripple. I actually predicted it would be the focus of the SEC's motion for summary judgment. The SEC argued it, but not as much as I predicted. The SEC didn't go transaction by transaction on sales, so the offer is the biggest danger. Now, so that's the quote, end quote. So, of course, part of the ridiculousness of all this is that it's been a 10-year offering in that case for this point, which doesn't have an ending date, according to the SEC, effectively, right? Which makes it stupid as hell. But check this out. This is where it gets even more interesting, though. So, Bill Morgan, who was an attorney within the XRP community, he shared this screen grab, and it's talking about Ripple's sales, because Ripple sells XRP, they also buy XRP, and there's a figure on the screen. I don't feel the need to read it. You can pause here if you want to take a look at this real quick. So that's the screen grab he shared. And then attorney Morgan wrote the following. Just thinking, John, but if the only Ripple sales of XRP since June 2019 are to users of on-demand liquidity for immediate cross-border payments, and not as an investment with an expectation of profit, what offer, and that's the keyword offer, what offer is there that is to a buyer not buying XRP for consumptive on-demand liquidity cross-border usage? And attorney Deaton responded to that with this perspective. He said, personally, based on the way the SEC chose to plead this case, an almost all or nothing approach, i.e. all sales, past, present, and future, are unregistered securities, I believe the only victory for SEC is that Ripple offered XRP as unregistered securities between 2013 he wrote 2107, he meant 2017, obviously. So a 4-year time span. So let me just pause here. Again, to be clear, what he's saying is, if the SEC is going to end up being victorious, then it's going to be because the judge finds that Ripple offered sales of XRP, but it's not about the sales themselves. Which, if it's law, it's the law. But it's just kind of ridiculous giving, I'm just like reflecting upon all of the nonsense arguments from the SEC for 2+ years now. And it comes down to this. Because this is not not solely what the SEC has been asserting. They've been asserting all sorts of other completely unrelated things, and they're not citing specific transactions. So if it comes down to the technical offering, I'm just going to be rolling my eyes. If that's the headline that breaks when we finally get the verdict on this case, when those news headlines come out, my God, and maybe that will happen, but it's stupid. STLLPID, stupid. That's what I think. And then attorney Deaton says, if true, there won't be an injunction, no disgorgement, but a fine. But as you know, I think the chances of a jury trial are higher than most people believe. To be clear, if true was meaning if I'm right and the judge agrees with my analysis, a huge if, then no injunction, etc. So there you go. If the judge agrees, what attorney Deaton is stating here is that, and if this is the way it shakes out, so it's just, hey, you made an offer, but it's not about the actual sales because they didn't even cite specific sales, which you're supposed to do, then, no injunction, no disgorgement, which means, and so that would be the part where they're clawing back the money that Ripple took in from the sales of XP. So no disgorgement and no injunction. And so the injunction part meaning Ripple can go ahead with business as usual, as it occurred before this lawsuit began. There's just a fine because there was a technical offering, but no sort of a penalty for any sort of sales because, and this isn't a hypothetical where the SEC wins only on the offer side, but not on the sales side. That's what I'm saying. That's what attorney Deaton's talking about here, obviously. So there could literally just be a fine, and then after 2+ years, it's over. Can you imagine that? So think about this, because who knows? Like maybe we have to wait till June to get a verdict. Oh, I hope not. I hope we get one this month or next month. It's possible we could that quickly. But say it is June, so you're talking about 2.5 years, and if all that happens in the end is there's no injunction, no disgorgement, but some sort of fine. Oh my, dear sweet baby Jesus. Dear sweet baby, I'm going to rip all my hair out. I have a luscious head of hair. I will have no hair after this. God damn it. So I sure as hell hope. I don't know. Actually, honestly, if that's what happens, I'll take it. But it's so absurd if that is indeed what happens, right? This is just freaking ridiculous. So then Attorney Bill Morgan had a couple more things to say. He retweeted that from Attorney Deaton, and he said, and this is really interesting too. Check this out. So I'm glad you stuck around to the end. For those of you still listening, check this out. Ripple claims it is true. I was extracting from its market reports. It would explain why the SEC never sought an injunction on current sales, not now being offered to anyone who could be regarded as an investor since before the lawsuit started. So pause. Think about that, folks. We've asked many times, if what Ripple's doing is so illegal, so wrong, and so obviously wrong, why didn't the SEC seek some sort of injunction to prevent Ripple from selling any additional XRP? Well, because it doesn't meet a single prong of the Howey test. Do you see? Because they made a shift to selling only specifically for transactions having to do with on-demand liquidity. All of the other sales to specific key partners, and none of them are retail, but all the other sales, they literally stopped all of those. And I couldn't remember exactly when, but apparently it was like 2019. So that, it looks like that is there. And I'd been wondering for a long time, haven't you? I never knew why. And so now this is a really good idea, I think, from Attorney Bill Morgan here. The SEC never pushed for that because they had nothing to go on from a legal perspective. And then Attorney Morgan says the following, and you'll love this. My theory, John, is when Ripple was being investigated in 2019 and told to stop selling XRP, they decided to limit sales to on-demand liquidity users, knowing such sales don't fit Howey. Basically, not any prong. Why otherwise limit sales to on-demand liquidity transactions and use Ripple? Ripple just outmaneuvered, and he says Ripple outmaneuvered the SEC because the SEC didn't understand the extent of on-demand liquidity adoption and that Ripple no longer needed to make other sales, and it could only harm Ripple in the United States by the filing of the lawsuit itself with an absurd allegation XRP itself is a security. So look, he's saying SEC might not have understood that, like in terms of like the war chest that they have, they don't need additional sales outside of on-demand liquidity sales to be just fine. The SEC may have, made a miscalculation on that front. And so that's why when Ripple got wind of, hey, something might not be going so well with the SEC here, they're like, okay, well, we're going to limit all of our sales to on-demand liquidity related. So that's an excellent theory. I'd never thought about that before. That might be the actual reason that we're seeing what we're seeing. And maybe after the lawsuit ends, maybe Ripple does go back to selling to other parties. I think they called that, I'd have to look at the quarterly reports, but I think they called that their programmatic sales, or I could have it backwards. But there's one type of sale that they quit doing some time ago, years ago. And I was like, oh, okay, well, I guess they're really just seriously dedicated to the on-demand liquidity related transactions. I was like, I don't know why they're doing what they're doing. Well, this is a pretty damn good theory, isn't it? Because they knew from a legal perspective, if the SEC were to ever sue them, they wouldn't have a leg to stand on. That's a pretty cool theory, I think. So, interesting stuff. Oh, what a complete crap show. This whole damn thing. I just want this to be over. I'm ready for this to be over. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.